All night, twinkie. All night, winking. And I want y'all to know that this gentleman, he's flying, but he's interviewing. So he's been jumping on flights back and forth. Yes, straight from Freeport. First flight, let's see that big up yourself. Yes, good morning, our bombers. Good morning, now, so they know everyone's so anxious and want to hear what's going on. I want to hear.
Recording in progress. Hey, Kwame. Hello? Hello?
Turn your mic on.
Yeah,
Good evening, everyone.
Good evening.
Good evening.
Hi, good evening.
I hope tonight we have a better line than last class. Everybody had a chance to read the 2 cases, and they just sent it out early.
Which 2 cases, Ms. Arch? I think we all
No,
were
no,
kind of
don't say
waiting.
that.
Nothing was sent. I checked. Nothing was
I
sent.
didn't receive anything.
I send a link.
Neither did I.
Don't say that, please.
Neither did
No.
I.
Thing was sent at all.
No, hold on.
No, I didn't get a chat. Anything either.
You didn't get an email either?
No, ma'am.
Man, I
Hold
didn't
on
get
one
anything either.
second. Hold on 1 second. Oh, what is doing now? Okay, just give me 1 minute. Let me send this to you. I don't believe this. I'm saying everybody is ready tonight. Let me put this up. Okay, not that one. Where did it go? Okay, hold on. Does Miguel say he's having problem with his internet? Who's the quickest person I could send this to? Out of the group.
Both or just one, or? I mean, if you could send it, would you want me to send it to the group?
Yeah, hold on, let me send, you want me, hold on. Let me get this.
You could post the
Become
links
so-
in the chat again.
Send it to all, let me see. Tap here to chat. Yeah, but then I have to, let me give you the names of the cases. B. And that's in the Supreme Court. And then the next case is Mitchell should have 2 L's.
You're sending something in the chat, Ms. Archer, or
Yeah, I'm using the name that came up, but hold on, let me see. Yeah,
I don't see anything.
everyone should have gotten it. You see it?
I don't see anything.
Is Tanisha on? Tanisha, do you see it?
I could see.
Okay,
Tanisha
all right.
saying, yeah, I see it, but I don't see anything from you in the chat.
Okay. So
Okay,
tell
I
me
got it.
once you found it.
Oh, yes, I see it, but where is it?
You don't see it?
No,
I
have my
think you only
looking.
sent it to Tanisha though. I don't think you sent it in the chat for everyone.
Because the chat is there. Nothing's in
I'm
the
trying
chat.
to get it to say send to all, but it's not moving.
Oh, okay.
It's not allowing me to do it. Tanisha, can you send it?
It disappeared when I tried to look at the chat again. I don't know where it
Oh,
went.
okay. Let me tell you what the name of the case is. Bentech, Bentech. Bentech Limited versus First Caribbean. Supreme Court. Let me know when you find it.
Good night. If somebody finds it, can you put it in the chat, please?
I found it. I'm trying to find a way to upload it to the chat. Otherwise, I'll send it by email.
Yeah, I think that may be easier.
Once you copy the URL, you should be able to just send it in the group if it's not like a PDF.
Oh, shoot.
Okay, you have it there?
I sent it in the email and I'm sending the link, but with the link, you'll actually have to hit the find button to look for the specific case, but I still send the PDF to everyone.
Okay, hold on.
What's the second case, Ms. Archer?
The second case is Philip A. Mitchell with 2 L's on the end. Philip A. Mitchell and Brenda May Mitchell versus Finco, Court of Appeal.
Okay, I have it.
So what I'm gonna do for next class is I will save them and then attach the documents in the email.
Okay, that one is sent as well. I'm sending you guys the link now.
Okay, they have it.
I can't locate the second one. Could you say what the name of the second one is again?
Philip A. Mitchell and Brenda May Mitchell versus Finco. Court of Appeal. Okay, so here. Okay. Who didn't find it just now? What's your email?
I already sent it to everyone's email, so I don't know.
They should have it. Eh?
Yeah, Miss Miller sent it to everyone's email, so
That's you,
I think
Kenneth?
everybody got it.
This is Kenneth. I have it.
You have it?
Yes, I
Okay.
do. Both of them.
Okay. Kwame, you have it also?
Okay, I have it. I see both of them in my email. I can check them right now.
Okay. Okay, check your email. So Kevin and Kwame, I send it to you. You got it?
I have both of them, ma'am.
Okay. All right, so we ready to start? Or you want me to give you a couple minutes to look at it? We will discuss pen tech first. And then afterwards we will do Philip and Brenda. Let me know when you're ready.
Good evening, everyone.
Good evening.
Last class, you said you were going to send some information for us to read up before this class, and you were going to try to send it before Friday. Did you get to send any of that information? Because I didn't receive anything up until
That's the two cases I'm talking about now, which I did send to Miguel to circulate. You have it?
No, ma'am. I left
Okay.
as of leaving work. I did not receive anything.
Okay, let me send it to you. I'll send it to you right now.
Mr. Pratt.
His phone is not working, which I didn't know until I called him just now. He's having internet problems.
Okay, I would prefer it to be sent to my personal email versus my work email, please, since
Okay,
I'm
give us.
no longer at work.
Okay, send it to me. Tell me what it is.
J Bethel, sorry, let me type it in the chat there.
No, tell me, I'm typing now. 1 L or 2 L's.
I'm gonna tell you which one to send it to. I have a couple of emails I need to send it to. This particular one, it is 1 L.
Okay.
And it's actually Janine, Janine.
JANINE
Correct. 32 at Gmail.
32 Gmail. Okay. Don't move. I'm about to hit send. Okay, it's gone. Let me know if you received it.
I will.
Okay. Both cases should be in it. JANINE
Correct.
BETHEL. Right.
Correct. 32 at gmail.com.
Mm-hmm. Do you have it now?
Not as yet.
What happened?
Found us alive, you know.
JANINEBETHEL at 32gmail.com.
No.
What?
Janine Bethel 32 at gmail.com.
Okay, all right. Let me start. Oh God, it's doing something else now. My own jumping. Hold on 1 second again. Come on. Okay. JANINEBETHEL.
Correct. 32.
Uh-huh.
32
at
at
Gmail.
Gmail. Correct.
Okay, you should have it now.
Yes. Christine Archer.
Yes.
Got it. Thank you.
Okay. So I give everybody about 10 minutes because I want us to really go through the last case, which is the one on Philip Mitchell. But just so you can just read the summary to see what the two cases are about, and then we'll begin. So what I'll do after this class is the cases for next class. I will download those and send them to you all tonight. So if anybody else wants to change their email, you need to let me know. Let me write yours on my roster.
Okay, Kenneth Gibson.
Hold on 1 second. Let me write down Janine on.
Okay.
Okay. Okay, Kenneth Gibson, what you want me to put yours as?
That's NOS
Uh-huh,
BIG,
uh-huh,
the number 6
uh-huh.
at msn.com.
Okay, let me repeat it for you. NOSEIG6 at msn.com.
That's NOSB as in boy. That's Gibson's,
NOSOB as in
Gibson spelled
boy.
backwards.
Okay.
Okay, the number 6
Oh,
at msn.com.
okay, I got you. I
Okay.
got you. Okay, I got you. Because I'm going to send you more than 2 cases this time.
Okay, thank you.
Okay. And everyone else, I'll send them to the list that's here from Miguel. Okay. So if anybody doesn't get it by tomorrow morning, send me a note. Because it may be that I have your email incorrect, just in case. Or when you're ready to begin, let me know, okay? I know everybody is still reading. Should I begin? Or is still reading? Ashley?
Still was reading, Miss Archer, but you could begin.
Okay. All right. So module 3 is about different types of mortgages. So the first thing you have to realize is that when you go to the bank to apply for a mortgage, the borrower is not getting a mortgage. What he's doing is he's giving a mortgage to the bank. What the borrower is actually getting is a loan of money. And that loan of money is what you call a mortgage loan. The mortgage itself is the security for the bank. And the borrower realizes that once he signs that mortgage deed, then he has an obligation to repay and repay the loan in full. So the whole function of a security is twofold. It provides an incentive for the borrower to repay, but it also on the flip side of it says that if the borrower fails to repay, then the lender then has the right to sell. So what exactly is a mortgage? A mortgage could be defined as a conveyance of land for the payment of a debt or the discharge of some other obligation for which it is given. Another way you can say a mortgage is an interest in property, in real property, and is created as a form of security for loan or payment of a debt. What's money for wait? Hold on one sec for me. Okay, sorry about that. That's a brief interruption. So when you define a mortgage, always remember from when we started the first class, what you're actually doing is you're transferring the legal interest to the bank and the borrower retains the equitable interest. So really the mortgage is an interest in property and is created as a security for a loan. And during the duration of that loan, of course, you have to repay that debt. And once you repay the debt, then you actually obtain back the legal interest in that property. So the borrower who offers and grants the mortgage is called the mortgagor, and the lender who provides the money is called the mortgagee. And you see that when you read the mortgage document, you see mortgagor and mortgagee. The borrower is the mortgagor and the lender is the mortgagee. Now there are different types of mortgages, and they're basically based on three types of security over land or over real property. One is a legal mortgage, and this confers a legal interest on the mortgagee. Remember, the mortgagee is the lender, and it may only be granted by the mortgagor who has the legal estate in the land. So that means that if you were to go to the bank and you're going to say, I need to apply for a loan, and I'm going to give my legal interest in the property to the bank as security, then that is a legal mortgage. A legal mortgage always gives the lender more security. And that's why the bank always opts to have a mortgage. The second is an equitable mortgage. And an equitable mortgage is similar to having a life interest. So that confers an equitable interest on the mortgagee. And it may also be granted to the mortgagor who has a legal estate. So this is where someone, let's say someone passes away, and in the will they say that my aunt is to stay in this house for the rest of her life. And upon her death, is to go to my nephew. So that means that she has a life interest in that property. So an equitable mortgage is often used to secure short-term indebtedness. Because don't forget now, that equitable interest is only based on a life interest, and that life interest can terminate at any time. So you don't want to extend an equitable interest in a property for a long duration of time. Even though the person may live until they're 50 or 60 or maybe 80 years, that is the chance the bank is not willing to take. So it's normally done for a very short period of time. The last one, the third one, is an equitable charge. And this confers an equitable interest on the chargee, but with more limited rights than an equitable mortgage. So what's a legal mortgage? A legal mortgage can either be any one of the following. A lease, where the mortgagor grants to the mortgagee a lease of the land, and that's rarely used today, or a legal charge where the mortgagor charges his land to the mortgagee by deed. And you notice that most transactions with a bank is done by deed. A legal mortgage by charge is the same as a mortgage over land, and it gives the mortgagee all the rights and the powers in law, including but not limited to the power of sale in the event of a default by the mortgagor. Under the terms and condition of the mortgage, the mortgagor effectually grants a charge to the mortgagee over his land by way of a legal mortgage, which is typically granted by deed. An equitable mortgage is an alternative to a legal mortgage, and it may be created first by an agreement where the borrower may agree with the mortgagee to execute a legal mortgage if required to do so, or it could be by a deposit of title deeds. If a deposit of title documents to the lender is merely for safekeeping, and then such a deposit does not create a legal mortgage, as in the case of a deposit made to the lender as a security for a mortgage. And you know, this is some of the issues that the banks were having some time back, where mortgages were paid off and the title documents still rest with the bank. And persons were not coming to collect their documents. The mortgagor and the mortgagee, for the purposes of an equitable mortgage, normally execute a document known as or similar to a memorandum of deposit, which the mortgagor signs to evidence his intention to create an equitable mortgage only on the terms of the arrangement with the mortgagee. The memorandum of deposit, the equitable mortgage, may contain an undertaking to create a legal mortgage if necessary or required. The memorandum of deposit is in the form of a deed. It may include an irrevocable power of attorney, which may give the bank or the lender the power to sell or appoint a receiver in the event of a default, or declare the bank as mortgagee. A trustee of the land with the power to appoint itself as a trustee and thus exercise a trustee's power of sale. No, it should be noted that an equitable mortgage is only actionable if it is in writing and signed by both the borrower and the lender. An equitable charge, the mortgagor, in consideration of the loan or financing to the lender, equitable mortgagee, agrees in writing to allow specified property to act as security for the loan. The bank must apply to the court in this instance for an order to sell the property in the event of a default. And a second mortgage is where a mortgagor may create a second or subsequent mortgage of property, which will rank after the interest of the first mortgagee, if it has taken the relevant steps to protect their interests by stamping and recording the mortgage document. The second mortgage will rank after the first or any prior mortgage. To create a second mortgage, the mortgagor may use his equity of redemption as security for further borrowing from a lender. Additionally, there is no possession of title documents by the second mortgagee, if different from the original lender. However, the registration of the first mortgage and notice of the same does improve the legal position of the second mortgagee. And you know, most banks, if you wish to have a second mortgage, it's normally done at the same bank with the same mortgagee. Any comments? No comments?
Archer, I have
Who
a
wants to
question.
start Bentech?
Ms. Archer, there's a question I have.
I'll start Bentech and then you can join in.
Hi, Ms. Archer.
So Bentech is a company that was
Ms.
owned by
Archer,
Dr.
somebody
Glenn
was saying they had a
Beneby.
question.
Go ahead, go ahead.
Hi, Ms. Archer. I don't know if you can hear me, but you can hear me now?
Yeah, I can hear you now.
Okay, there was a question, or there's a question I have. Sorry,
Go ahead.
this is Mike. There's a question I have on the equitable charge, I think. I think that's what it was. Where it says that is not actionable unless both persons sign off on it. I think that was on the bottom of the equitable charge, where they said that you wouldn't be able to take action unless both parties sign on it. That means that if we have not the equitable charge, it's the equitable mortgage. So the mortgage and the mortgagee, for the purpose of the equitable mortgage, I think execute document on, hold on. And the memorandum of deposit is in the form of deed. It may include an irrevocable power of attorney, which may, right? But it also says that the last statement on it, it should be noted that an equitable mortgage is only actionable if it is in writing and signed by both the borrower and lender.
The borrower and the lender.
That is so that is before or when you put it in place, it has to be signed already. That's what they're saying.
What you mean now I don't understand what you mean when you put it in place. What do you mean? Give me an example.
At the onset, take for instance, I put together an equitable mortgage, right? Go to the bank or I sign off on it. If I go in default, do they use the same document to action it? Or do I have to come back in and sign again to have it action?
No. It's done at the beginning.
Okay, because that's what I'm saying, because that was sort of ambiguous to me.
Okay,
It should be noted that equitable mortgage is only actionable if in writing and assigned by both the borrower and the lender. So
yeah.
I figured that I was trying to figure out if that's at the beginning of the mortgage, because ain't nobody coming back to say, hey, lucky I can sign for you to take.
No, that'll never happen. No, you won't get paid.
All right, I got you. All right, that's good.
Someone else had a question. Okay, someone else had a question.
No, I think that's the only person with a question.
That's the only one. Okay, so let's look at Bentech. You want me to start?
Bentech. Which one of these are Bentech?
Bentech.
Oh, okay, I see it. Sorry.
Okay,
You're right.
First Caribbean. So this is where Bentech took out a mortgage with Barclays in 1994 for $600,000, and then in 1998, that's 4 years later, came back for another further charge of $204,000, and this time Dr. Benaby himself was the guarantor for this loan. He then in 2003 sought a second further charge for an additional $498,505. And then in 2011, he approached the bank for $250,000. And so what the bank did was they did a consolidation. And they advanced him $25,000 in 2011. So by that time, then his loan was $1.2 million. And then he got another small loan for $37,000 to assist with replacement value for his insurance coverage. What's the first thing you see looking at the breakdown of this loan? If you're doing loans now, what's the first thing you see? Being mindful that the credit bureau is coming. What looks wrong with this?
I guess I'll take a stab at it. Perhaps that there's nothing to, I guess, secure the additional amounts that are being loaned to him. So there's no additional property. So it's kind of confusing as to why they would offer him more funds, not knowing.
Exactly.
And so there's kind of a backstory there that they're not admitting in this.
Because I'm looking at, he gave his personal guarantee. This is only one condo. And he is at the point at paragraph 5. He's
Out, Ms. Archer.
Ms. Archer, we can't hear anything from you. I think your speaker's on mute.
the state. Oh Lord. The bank responded stating that the loan was satisfied in 2003 and there's no requirement to retain those documents either. So you see what happened when they did that consolidation for him. Those records from Barclays were all, according to the FTRA, they were all destroyed. So he wants a reconciliation done from 1994.
Okay, Ms. Archer,
Go
in
ahead.
case you was talking all the time, we could not hear you for the past 3 to 5 minutes. The whole time you were talking. The whole time you were talking, you were not there. It looks like you got kicked out of your own Zoom meeting.
Oh God. Okay. So, all right. So we already made the comment. Remember when we agreed that something was not right with this loan from the very beginning, because he had a condo and then he personally guaranteed it. But the issue comes when he started saying that the accounting, he did an audit and the accounting is off, and that $167,000 was not applied to his account. Now, bear in mind now, when he was granted the first loan, it was under Barclays. Then the bank became First Caribbean. And so under the Financial Transaction Reporting Act, 7 years had gone by. So those records were gone. And that's what the banks intimated to him, that the 7 years by law, those records were gone. So he came again and he said, Baker Tilly found findings to the bank, which found that $167,000 could not be accounted for. The bank responded stating that the findings were incomprehensible and inconclusive. Then the judge who retired ordered the summons, and he ordered that Baker Tilly meet with Dr. Benaby with a view to reconciling the account and reconciling their dispute. And the parties were still unable to amicably resolve their dispute. The accountants reported that there were discrepancies with Bentech's account and that about $306,000 was not posted, thus posting a balance of $847,696, which it ought to have been $541,285. So Bentech's attorney requested that the bank provide statements from 2017 to date. And the bank attorney provided the requested documents. Now, if you go further down at paragraph 22,
Got another
you still hear
question.
me? Go
Yeah,
ahead.
got another question. It's right there. You said it's 7 years according to the Financial Reporting Act, right?
Yes.
The next question is that if you have 7 years, I thought as long as a mortgage or a loan or whatnot was in play, you the 7 year you supposed to have that on it on the individual's file. Or it should be attached to his file, as long as his loan or whatnot was active. I was thinking if it's closed, you have up to 7 years to keep it.
I agree with you, but this is what the bank is saying now, so you have to go on further to see what the court says.
Okay, because as long as from what I remember, as long as a loan is open, they support the document should be held. On the
I
record.
agree with you. Yes.
All right.
Okay. Okay. So go to paragraph 22. Paragraph 22 says, according to North, the statement of claim is predicted upon an alleged breach of contract, but fails to demonstrate in its pleadings, firstly, the existence of a contract, and secondly, the bank's failure to perform the contract, and thirdly, the damages resulting from the breach. He submitted that it is unclear whether Bentech relies on an implied or express term in the commitment letter or mortgage deed, and that throughout the statement of claim, Bentech failed to refer specifically to the contract, which forms the basis of its claim of breach of contract. So you see now where the attorneys are leaning towards a different story now. They're representing the bank. And they're saying that when Bentech made their claim didn't refer to a particular clause or paragraph in any document. And so they're saying that they fail to actually identify where's this breach of contract. Mm-hmm.
Wasn't one of the issues that I think it was Barclays that originally extended him the mortgage, and that
Yes.
when Barclays went out of business, the current bank would have then taken over all of it. They
Yes.
would have bought off all the loans. And I think the issue, it appeared to be the statement of claim wasn't specific enough in terms of what Bentech was seeking, and they weren't able to specify the amount claimed in their suit against First Caribbean, because they themselves didn't appear to have any of the records, even though they were making the payments and never missed the payments. They couldn't specify.
You went out.
The court didn't entirely strike out the application, but they sent them back to amend it.
Yes. At the end, that's what they did. They sent them back to amend it. At the very end. But I wanted to just to read as we go through it, so they could understand why the court came to the decision what it did, and to look at the way the bank is represented and the comments when they go to court, when they're dealing with these matters. So he said that I agree with Mr. North for the bank that the statement of claim is vague and deficient, and that it lacks the particular necessary to equip the bank to defend the claims against it. The date of the mortgage is not specified, and as Mr. North correctly expressed, it's not clear whether the obligation that Bentech alleges to have been breached was an implied or express agreement. The vagueness makes it difficult for the bank to put a defense to the assertion. So he says, notwithstanding, I do not accept Mr. North's submission that the statement of claim does not assert a cause of action. The foregoing paragraphs establish that Bentech asserts the existence of a contractual obligation, albeit unclear as to the source of the contractual obligation and whether the obligation was implied or expressed. It alleges a breach, namely that the payments were not applied to the mortgage account, and damage caused by the breach, namely the bank's failure to properly apply the mortgage payments to Bentech's mortgage account, resulting in Bentech having to take the loan of $25,000 in 2011 for repairs to the property. And down in 26, he said he further argued that Bentech has not particularized or demonstrate how the $167,000 plus was ascertained, which it says is the sum which it paid, but was not applied by the bank. And then he said later down, he said the bank is unable to put in a defense to this unorthodox statement of claim. So with respect to the completeness of the account records provided, the bank's position is that the documents they produced to Bentech is the complete history of the loan, that the 1994 Barclays loan and the subsequent 2003 loan have been settled. On that footing, they say that the business relationship in respect of those loans has ended more than 5 years ago, thereby freeing them from the obligation under the FTRA to retain the records in respect thereof. However, Bentech maintains that none of the loans were satisfied, and therefore the documents which have been produced do not cover the entire period of the loan. It seems to me that the commitment letter in June 2011 may have incorporated the 94 and 2003 loans. Otherwise, there may more than one loan subsisting. If the commitment letter did, then Bentech may have a very steep hill to climb, given the provisions of the FTRA. Bentech's audit was inaccurate because the record on which it based its audit was incomplete, which is directly contradictory to the bank's contention that they provided all the records. But I hasten to add that the bank has consistently maintained that although the loan commenced in 1994, there had been subsequent refinancing over the years, and therefore the commitment letter dated the 17th of June 2011 is really the starting point for Bentech's account. Both the bank and Bentech assert that they will rely on the commitment letter dated June 2011. So you see, if you go back to the question you raised for the FTRA, they came to the conclusion they would start with 2011. Because by the time when FinCo came, they had already consolidated it. And he really should have done an accounting at that time, which he didn't do. So Bentech was asked to where's the ending right here? Bentech shall file and serve an amendment statement of claim and to strike out the statement of claim that they submitted in November 2018. So the question when you asked about the FTRA, you could see that they all agreed that they would start from 2011 and not 1994. Now, how he came up with these discrepancies from 2011 up to 2018, that is something that he's going to have to argue at a later date. Any comments? No comments? You still going through it?
There's no comments from me.
So you agree with that so far? That after First Caribbean took over from Barclays, that the starting point is 2011?
Somebody was saying something. It seems as though there's a certain level of responsibility that the mortgagor must have, that I don't know how fair it is, I guess, being that the banks are this huge institution that have the capacity to like properly audit and keep proper accounting as they are required to. However, technically, I mean, when the loan was consolidated and moved to another institution, it practically speaking was satisfied because that's the process you have to do, right? You technically would, by moving that loan to another bank, they would satisfy that with the old bank. And there's no longer an obligation that either you or the bank you once were with, y'all don't have any business with each other anymore as it relates to that loan. But in
Agreed.
terms of like a contract that might have been breached in some way, I don't think if they did do something wrong, I think that it's kind of unfair to find that because the loan is no longer with them, they have no more business because they might have breached a contract or breached some part of their mortgage at the time they did have obligations to Bentec. And therefore that cannot be properly proven because they don't have those records anymore. So, and we also don't know if they don't have those records, if the loan was properly consolidated and moved, because what if some numbers were off or, you know?
Right, so that's the thing. First Caribbean could say anything based on that.
Yeah.
Well, I look at it like this: if Barclays in turn had said, "Hey, look here, you take it over. We're merging now. It's all one company." Now he went back and he said, "Okay, I will now do this under First Caribbean's umbrella." He had to sign a statement of agreement and contract at that point in time for the further charge. So he agreed to whatever figures they
Whatever
had
number.
at that point in time. If he did not do what he was supposed to do at that point in time, he gave up all his rights. So if he was saying and he believed that it was out $164,000 before, from 1984 to present, or to 2018 or 2017 when they went to court, the situation is he signed off on everything from 2011. That didn't finish. So he basically gave up all his rights at that point in time. I mean, from what I'm understanding now. So basically the contract now starts from 2011.
Yes.
So if he in turn now has any obligation, the obligation would be from 2011 to, based on whatever figure, from 2011 to present. The problem with us Bahamians is that at the end of the day, we don't read
fine lines.
or in the excitement of getting money, we don't follow through and think about what's happening for the long term. So he basically gave up his rights when he signed those documents.
Yeah, because he should have, realizing that the bank was being taken over by another bank, he actually should have done some reconciliation. You coming after the fact now to say that the accounting is not right. He should have done that when he went there in 2011.
And if the bank was wrong and they at that point in time say, okay, I can fix my accounts now and say, okay, we'll start fresh from now, because I am not certain what Barclays did, but under First Caribbean, which is now consolidated between Barclays and I think I forget what the other bank was, but anyway, they came up with First Caribbean. So whatever it was at that point in time, they say I can fix my documents now. We can start from now. It is what it is.
And I don't think he's going to get very far when he goes back to court. He's not going to get very far. I have another one here. Hold on, I'm going to send it to Janine and to Kenneth, because it's easier to type. Hold on. I want you to look at this case. Similar. Yep, this video. And then share that with the other one, with the other students. I just sent it. Tell me if you got it. Received it?
Not as yet, still waiting.
Oh, Lord. Sound like you got it.
No, that's something else.
Oh,
Yeah,
Lord.
yes, I did. Yes, I did.
Okay, share that with the class. Put that in the group.
Oh, I'm logged into something on a different phone,
Kendra, can you send it? Because this is a lot to send this to. Let me see. T. Simmons.
I don't see Tony here.
T-A-R. I'm trying to send it to someone right now. Camille Simonet. Okay. Tell me if you got it. I sent it to Camille, Tony, and Tariel. I want to do it to Tanisha. Dehana. Anyone else I miss out? Ashley? Everybody got it by now?
No, Mom, I haven't.
El Bethel.
That's Lisa.
That's fine.
Yes, I got it.
I didn't get it.
Who didn't get it?
El Bethel.
I'm sending it to you right now.
Okay, thank you.
Okay, and
I didn't
Kelisa?
get it.
Who's that? Gabrielle?
Gabrielle. Mm-hmm.
Gabrielle, hold on.
And I am
You're
still
not even
waiting.
on, you're not even on my list. Go ahead, give it to me.
And I'm still waiting.
Ashley is still waiting.
Okay, Ashley, okay, I could do Ashley.
I mean, who is, well, Miss Sasha.
Okay, Lisa?
I have.
Ashley.
Okay, Lisa.
I send the
That's when Dawn.
attachment to our email, so everyone should receive that. I just attach it to the email as the PDF.
Okay, good.
Okay, got it now. Bank of the Bahamas.
Got it?
Person. Mark.
Okay.
Okay.
I sent something in the group, Mitchell versus Finco, as a PDF. I don't know if anybody could access it from them.
Yeah, but this one we're gonna do now is Bank of the Bahamas and Mark Oscar Gibson.
Yeah.
Oh, I ain't get that one yet then.
Check your email.
One moment. Okay, received.
Okay. I'll give you a couple minutes. This one is not that long. But this one is on that, in that similar vein. So background, Gibson was an existing customer of the bank, of Bank of the Bahamas. And he obtained an additional new commercial loan in the amount of $80,000 in 2006. The new loan, according to the commitment letter, brought Gibson's indebtedness to the bank to $307,000. The two loans have required separate payments from Gibson, $1,700 and 1013 respectively, and the loans were secured by demand mortgages over property belonging to Gibson. In May 2009, the bank and Gibson agreed to the restructuring of the loan facility. See, this one is getting trouble. The earlier period between November 2006 and May 2009 did not reflect punctual and regular payments of the amounts due by Gibson. The introductory paragraph of the commitment letter, 26th of May 2009, reflected the economic circumstances under which the loan was being restructured. Bank of the Bahamas International Bank recognizes that the weakness in local economic conditions precipitated by the global recession has created a certain degree of financial disharmony amongst families and individuals across almost all business sectors. As a result of this, the bank is seeking to provide our customers with financial relief based on individual circumstances. You all remember that in 2009? Sounded like the recession. So the restructured terms reflected a loan sum of $305,000, which was to be repaid over a 20-year period and to mature on May 30th, 2029. The consolidated payment was $2,558. Was there much difference between the two? He was paying $2,713 first. They consolidated and now the payment is $2,558 and it's for 20 years.
Good night, Mr. Acho. I still haven't received the cases yet.
No, Darius,
No,
hold on. I don't even have you on my list. Hold on. Let me do a forward. You don't have any of them?
Okay, I think somebody just posted in the group.
Okay, you have the one I'm reading now?
I think that's the one they posted in the group. I can put in
What's
the
your
website
email?
right now.
So give me your email. So when I send them tonight, you'll get it.
Can we put it in the chat or just
No,
text?
just tell me what it is.
So it's adamsdarius@hotmail.com.
Adams Darius
At
at
hotmail.com.
Hotmail. Okay. Got it.
All right, thank you.
Okay. So I'm saying now, if you read paragraph 1 versus paragraph 3, I don't see much difference in this restructuring. So then on December 2011, the bank alleged that Gibson had been in arrears of the loan facility and they commenced action against him. And the statement of claim endorsed on the bank's writ claimed the following relief: the sum of $295,713 interest and of course cost. The bank applied for summary judgment on the 13th of May 2019. Gibson relied upon affidavits in support of his case filed on the 14th of December 2012, 20th of December 2019, the 8th of January 2020, and the 16th of May 2020. He also relied on an affidavit of an accountant, Lyndon Maycock, also filed on the 20th of December 2019. The bank says that Gibson did have sufficient funds on his account to satisfy payments for October 2009, January to March 2010, August 2010, October to December 2010, May 2011, and August 2011. Gibson admits to not having paid anything on the loan facility since 2016. In his 16th of January 2020 affidavit, he asks that he be permitted to pay the sum he says is due, $286,113.17 within 240 days. No comment on that one. Then Gibson filed a defense and counterclaim alleges that he was not in default of the payments under the loan facility. He relies on an entry in his accounts of the bank, which identified as principal disbursal on the 4th of September 2009. He says that the last disbursement made by the bank under the loan facility was made on the 4th of September 2009, and therefore his payments ought not to have begun until the 30th of October 2009. rather than the 30th of May 2009, as asserted by the bank. Gibson says in his defense is the result of a provision in the 29th of November 2006 commitment letter relating to the loan purchase property and inventory for his business, which said that, quote, repayment of $1,700 principal and interest per month commencing the 30th day of the first month following full disbursement of the loan proceeds. Gibson, it seems, alleges that this is relevant, as the 26th of May 2009 commitment letter also provided that all other existing terms and conditions outlined in the original loan agreement remain unchanged. Gibson sought to rely on this provision on an assessment made by Maycock, that's the accountant, that he was not in arrears of the loan. Maycock, who qualified his assessment of the state of the loan as not satisfying internationally recognized standards, premised his assessment on the fact that the payments were due to commence on the 30th of October 2009 and not the 30th of May 2009. And there was no reason provided by Maycock for this view as to the date the loan repayments were to commence. So here comes the judge. The judge says, the evidence and conduct may be seen in the following. It is accepted that the restructured loan was for 20 years to be repaid monthly, with a maturity date of the 30th of May 2029. It seems clear that the payments would begin at the latest in June 2009. The payments therefore could have been agreed to commence in October 2009, some 5 months later, could not have been, as suggested by the Gibson defense. This effectively deprived the bank of 5 payments and would not amount to a full repayment of the loan by the maturity date. Gibson himself has earlier sworn in paragraph 6 of his affidavit of the 14th of December that his payments were to begin in June 2009. So his pleadings and later submissions contradicted this. Gibson's conduct also demonstrates that he understood, contrary to his defense, that payments were due from at least June 2009. Gibson began making payments on his account in the new amount of $2,558.30 on the July the 3rd, 2009, and not October 2009. A defense by Gibson that the full sums were not disbursed until the 4th of September 2009 is untenable. This was the restructuring of existing loan facilities, and therefore no monies were being disbursed from the bank, as had occurred when Gibson was purchasing the property and inventory under the prior facilities. Any movement of funds were purely notional. The monies being loaned to Gibson had long been received by him or disbursed on his behalf. The loan balance on the 27th of May 2009 in Gibson's accounts with the bank was already at $306,000 plus. Bearing in mind the loan was $305,000 plus. The bank explained, without any serious dispute, that the 4th of September 2009 entry was an internal allocation by the bank to bring the loan account and not to bring the loan current and not a disbursement to anyone. Say further, Gibson's submission as to the bank not requiring payment until October 2009 is not only against the weight of the evidence or his conduct, but also defies economic or business sense. The judge says if the payments ought to have commenced in June 2009, Gibson ought to have paid $67,000 plus. His payments, therefore, fell far short. So having considered the matter, I am satisfied that the bank had made out the case for summary judgment. Gibson, in my view, was clearly in default of the loan facilities and did not have a real defense to the claim, save maybe as to the amount ultimately due to the bank. Further, in light of Gibson's admissions that he had not paid the loan facility since 2006, I give summary judgment for the bank for breach of the mortgage loan facility with damages to be assessed by the registrar. Any comments on Mr. Gibson? Everyone is still reading to see how Mr. Gibson got himself in this mess.
Well, I see how he get himself in this mess. I ain't gotta read that no more. I'm finished.
But he admitted he didn't pay the loan, so I don't figure. Anyhow,
He ain't paid from 2006. They
Yeah.
restructured in 2009, and from 2009, it wouldn't have been much different.
no,
In connection with the payments.
but the restructuring didn't help him.
But again, that was only to clean up everything, to give him a second shot. So when they go to court at the end of the day, they could say that they tried to work with him and he still was unable to meet the payment.
But you see, I don't understand. He hired an accountant and then he started to rely on this phrase, principal dispersal, to say that there was some disbursement to him. And he knew that was a consolidation. They rewrote it, reduced the payments, extended the period. But he's now saying that it shouldn't have started until the 4th of September because of this word, principal dispersal. But no funds were paid out, and he knew that very well. He knew that. So he lost. Poor thing. So let's go now to Unit 4, mortgage over land. And then we'll look at the last case, which is Mitchell and Brenda May. So when the loan is repaid and the land becomes free of the mortgagor is said to redeem the land. So during the currency of the mortgagor's residual rights in the land is known as his equity of redemption or equity. Its value is the value of the unencumbered collateral minus the value of the secured loan. A mortgage implies the transfer of the mortgagor's interest in the property as security with a proviso for the transfer on transition of the mortgage. A charge implies a mere right to look to the charger's property to satisfy an obligation without such transfer. So when the discussion of security is raised, there are two distinct issues. What is the nature of the interest in the land or collateral? That is the subject matter of the security. For example, the mortgagor may have a freehold or leasehold estate in the land, and its interest may be legal or equitable. Also, the land may be unregistered. The nature of the security interest created must be ascertained, that is legal or equitable mortgage or charge. When a secured loan is obtained in relation to a mortgage, the borrower, the mortgagor, gives the lender, the mortgagee, an interest over the land, a right in priority to other creditors, and the power to obtain repayment of the loan and any interest due through numerous legal remedies, including but not limited to power of sale, if the borrower defaults. Enforcement of the mortgagee's rights through established and actionable legal remedies is a fundamental premise of the law relating to mortgages. For example, even though the mortgagee must obtain a court order in order to effectuate a power of sale, the power of sale does not make the mortgagee the legal owner of the land. The mortgagee is merely exercising its right to dispose of the land by sale so that it may repay itself what it owes under the mortgage loan. It should be noted that any surplus obtained in the sale of the mortgage property belongs to the mortgagor, subject to the rights of other mortgagees to whom the mortgagor may have given subsequent mortgages to the same land. So there's equity of redemption. The mortgage loan is a contract under which the mortgagor offers a legal interest or mortgage over his land in return for an amount which the mortgagee loans to him and under which both parties undertake to carry out certain legal obligations. The mortgage acts as security for the mortgagor's due performance of the contract. Once the mortgagor performs his obligations under the terms of the contract, that is the mortgage loan, his land is released from the mortgagee's rights or legal interest in the land and freed from his personal obligation to the mortgagee. If the mortgagor fails to discharge his obligations under the mortgage loan, that is, failure to repay the loan when it is due to be paid, he is in breach of contract and may no longer retain his contractual right to redeem his security by payment at a later date. However, under the equitable principle of the equity of redemption, the mortgagor has a right at any time after the contractual date of repayment to pay the loan and redeem his security. He must give notice of repayment or pay the interest on the mortgage loan. Although in a loan financing banking context, the equity or equity of redemption in relation to the mortgage is the value in the land, which is the difference between the amount originally borrowed and the amount presently owed to the mortgagee. In strict legal terms, the equity of redemption is the general rights of the mortgagor to redeem his security and discharge the mortgage or legal interest of the mortgagee over his land by repayment of the mortgage loan. So after giving notice of his intention to repay and paying the agreed amount of interest. So the equity of redemption represents the mortgagor's remaining interest in the mortgage land. For example, if the mortgagor has mortgaged land valued at $150,000 as security for a loan of $100,000, his right to redeem is worth $50,000 net. The mortgagor is allowed to dispose of that right by sale, or he may use it as security for another loan, which may create a second mortgage over the same mortgage land. Clogs on equity. There must be no clutter or impediment on the equity of redemption. In equity, the property belongs to the borrower, and the purpose of the mortgage is to provide security for repayment of the loan. In principle, the borrower ought to be able to get his property back by paying off the loan with his property in the original condition. The borrower should not place undue postponement of redemption. Note that the parties may agree to a long-term repayment, and early repayment might put the lender at a serious disadvantage. But this is why when you get a mortgage, some people like to come and try to repay the mortgage early. And some mortgages have a clause because there is a penalty if you repay the mortgage early, because the bank has already calculated that interest and that profit for the duration of the mortgage. Protection and perfection of mortgage or security interest under common law upon which mortgage
Sorry,
and
Ms.
land.
Archer.
Go ahead.
Excuse me.
Mhm.
Is the actual penalty normally close to the interest that the bank would have received? Is there a big difference in that, or they normally make it almost the same?
Almost the same.
Okay.
Yeah, because don't forget now, they've already projected this mortgage is for 20 years. Even
Right.
even if you make principal payments, you will see that they make it very difficult for you to repay it, say 10 years earlier,
Right.
because they're going to lose too much interest.
Right.
Yeah.
So, but I noticed that with some banks, they allow a certain amount of payment that you could make on the principal. Like I think they have like $25,000 a year. Annually, you can make anything at this. I guess you can't go over that.
Exactly, because they still have to make their profit.
Correct.
That's why you see some people, what they do is they borrow in stages. Rather than getting a 20-year mortgage, they'll borrow for 3 years or 5 years and turn it over like that, rather than getting this long mortgage. So they can pay it off in lump sums, get it like a small loan, rather than just getting a mortgage. So in English common law, upon which Bahamian mortgage and land law is based generally, and the Conveyancing and Law Property Act require the recording and filing of the relevant mortgage document and conveyance after the production of evidence of the payment of stamp duty. The legal requirement is necessary to perfect and protect the security interest of the relevant party to whom the property is mortgaged, against third parties generally without proof of specific notice to any particular claimant or any actual knowledge on its part of the prior interest. So a security interest, which is unrecorded or filed in the absence of a statutory provision to the contrary, may be perfected vis-a-vis a particular third party by notice to that person or by knowledge on his part. In general, an accurate and thorough title search of the particular property being mortgaged or used as security for mortgage will assist any prospective third-party purchaser or creditor in discovering the existence of an adverse title or security interest, whether created by the prospective seller, debtor, or by one of his predecessors entitled. The object of the filing or lodging of the mortgage document and other documents of title in support of the mortgage is to give notice of the security interest to such third parties. Although failure to file or lodge the relevant mortgage documents does not, in principle, affect the enforceability of the security as against the debtor himself. At the time of filing of the documents, security interest is of utmost importance in terms of the priority of interest of the secured creditor. It is important to note that in terms of the priority of security interest, particularly as it relates to mortgages in the Bahamas, the first document to be recorded in time prevails, notwithstanding the date of execution or creation of the document. Failure to file or lodge a security interest, whether a mortgage or a judgment order from the courts, will result in the fact that secured creditor is postponed to subsequent incumbency and loses out altogether to an outright purchaser, particularly a bona fide purchaser for value with no knowledge of the prior security and one who is not involved in any fraud or collusion regarding the same. It should be noted that where the mortgage property is a debt or other money owing as to person to whom the notice should be given, a mortgagee who gives written notice to the debtor gains priority over a mortgagee early in date who omits to give notice. The omission to give effective notice leaves the property under the mortgagor's control and deprives the second mortgagee of the chance of ascertaining the existence of the first mortgage by inquiry of the debtor. The filing of the relevant mortgage is important to the notice requirement and to protect interests of the first mortgagee, because the priority of the second mortgagee does not depend on whether it made inquiry. It depends solely on notice. However, a second mortgagee will not gain priority if it gave no value or if he had knowledge of a prior mortgage at the time of its advance. With regard to the priority and enforceability of real property taxes as a lien to the subject mortgage property after filing of the mortgage document, it should be reiterated that real property taxes represent the first charge over the property, which arises automatically by operation of law and does not require filing or lodging by the appropriate governmental agency. So those people whose properties were just reassessed must be mindful of that. That is the first expense that comes out of a property when it's going to be sold, the real property taxes. The first charge, which quite arguably ranks in priority to the mortgage security interest filed and created by the mortgagee, is better understood in the context of the legal obligation and liability of mortgagees as they relate to the payment of real property tax on the mortgage property, since those mortgagees will be deemed to be owners of the property where real property taxes remain unpaid, particularly during the currency of the mortgage loan. So what are the remedies of a legal mortgage? The first remedy is the action for debt. So the bank, the mortgagee, has a right to sue on the debt independently of the security if it wishes or decides to do so. The second remedy is entering into possession. A court order is required by the mortgagee in order to enter into possession. If the mortgagor is in occupation of the mortgage property, the eviction order is needed. The costs to enter into possession are borne by the mortgagee. Entering into possession is normally one of the initial steps in selling the mortgage property by exercising the power of sale. And there are a number of restrictions on the bank being able to enter into possession. If the mortgage property is a dwelling house, then the court has a discretion to adjourn the action if the mortgagor is likely to be able, within a reasonable time, to pay the sums due. In the case of Cornell versus Maltby, it suggests that there may be a general discretion in the court to refuse possession to a mortgagee if possession is not sought for the purposes of enforcing the security, but for an ulterior purpose. The third remedy is appointment of a receiver, and that's where mortgage property is leased to tenants. The receiver appointed by the mortgagee is paid rent directly by the tenants of the property rather than pay such rent to the mortgagor, who is the landlord. This is an attractive remedy only if the bank wishes to continue with the mortgage and the land is income producing. However, before the bank mortgagee appoints a receiver, it must make formal demand for repayment from the customer or mortgagee. There are extensive case laws setting out the duties of a receiver, Sylvan Properties versus Royal Bank of Scotland, and Downside Nominees versus First City Corp. Although the receiver is appointed as an agent of the mortgagor, he must take steps to protect and preserve the mortgage property. When it comes to selling the property, they owe the same duty to the mortgagor and others interested in the equity of redemption. And so this means that although they may obtain the best price reasonably obtainable, they are not obliged to take steps to enhance the value of the property or to delay a sale in order to achieve a higher price. The fourth one is sale of the property or power of sale. And this gives the mortgagee a statutory power of sale. Once it becomes clear that the mortgagor is likely to remain in default of his obligations, banks normally seek this remedy in conjunction with obtaining vacant possession. Similarly, under the terms of the mortgage loan, the mortgagee has a power of sale to sell the mortgage property in the event that the mortgagor defaults, even where the property is still occupied by the mortgagor, subject to obtaining an eviction order for eviction and following other legal formalities. And a mortgagee is not a trustee of the power of sale for the mortgagor, and he has an unfettered discretion to sell when he likes to achieve repayment of the debt which he is owed. In particular, the mortgagee need only have regard to his own interests and need not postpone the sale in the hope of obtaining a higher price or take steps to achieve a higher price. The mortgagee's only duty is preserving the value of the security and to obtain the best price that can reasonably be attained. So on the realization of security, exercise of a power of sale, the bank or the mortgagee must act reasonably and obtain a fair price for the mortgage property to be sold under power of sale. And then I gave you a case there of Standard Chartered Bank versus Walker and Walker, which you could read. And if you look, if you go further down, I have quite a few cases. And for next class, we're gonna discuss each one of those cases that we have here. I'm gonna give you time to read it. I want us to turn now to Mitchell, which is quite an interesting case. Who wants to start? Kenneth, you gonna start? Kenneth. Yes, are you starting? With the Mitchells?
Okay, what do you want me to start with?
Well, let's start, just give a summary of what this case is about, because they have lots of claims.
Okay, so the appellants obtained a mortgage and various further charges from the respondent over land at Twynham Heights. By letter of June 2009, the appellants were notified of a breach of the conditions of the mortgage and further charges by failing to make the loan payments. They were advised that if they did not pay the outstanding amount of $319,164.86, legal proceedings would be commenced against them. The loans were not brought current, and they refused to vacate the home to allow the respondents to exercise this power of sale. In the circumstances, an action was commenced by originating summons in the Supreme Court, whereby the respondents sought vacant possession and the amounts outstanding under the mortgage. The appellant filed a cross action to strike out the respondent's original summons. Between the end of the hearing of November 2013 and the delivery of the judgment, the appellant sent multiple letters to the court complaining of the delay in the delivery of the judgment. The appellants also sent a complaint to the Chief Justice. In April 2014, the trial judge gave judgment to the respondents and ordered the appellants to pay the outstanding amounts under the mortgage and charges. The judge struck out the appellant's cross action. He further ordered that in the event the appellants failed to pay the outstanding amount, they should give vacant possession to the respondents within 60 days. The appellants now appeal the decision of the learned judge. Held appellant dismiss.
Appeal dismiss.
Appeal dismiss. Cost to the respondents to be taxed if not agreed. The appellants contend that due to their demand to the trial judge to deliver judgment and their complaint to the chief magistrate, the trial judge should be perceived to be biased against them. When considering apparent bias, the test is whether the fair-minded and informed observer, having considered the facts, will conclude that there was a real possibility that the tribunal was biased. It is a proposition of law that judges must not only be free of personal bias, but also from the perception that they are biased. In the present case, a fair-minded and informed observer, knowing all the facts that are capable of being known by the public, would not conclude that there was a real possibility of bias on the part of the learned judge in rendering his decision in this matter. Regarding the validity of the mortgage, the appellant argued, hold on, I lost me. Oh, okay. Regarding the validity of the mortgage, the appellant argued that the terms of the mortgage cannot bind them, as what they signed was not a mortgage deed. Second, the appellants argued that there was no intention to be bound by the terms of the document, as the terms were not available at the signing. Third, they argued that the mortgage is available as fraud. The mortgage is invalid as a fraud, with the result that the respondent is unable to claim for indebtedness on any of the three loans. As was noted by the judge in the court below, it is not sufficient for a party to simply deny the validity of a mortgage and thus create a bar to the grant of the order sought. The court must be satisfied that there is some evidence which gives rise to the serious issue, in that evidence is sufficient, cogent to warrant trial. The appellants also complain that the indentures are not valid, having regard to section 2, paragraph 2 of the Law of Property Miscellaneous Provisions, Act 1989, the LPA, the section 21 and 45, and the second schedule of the Conveyancing and Law of Property Act, the CLPA. However, the LPA referred to by the appellants did not exist in the Bahamas. Second, the appellants have not provided any bias to support their contention about section 21 of the CLPA. The judge below ought to have concluded that a mortgage did not exist. Third, the provision of section 45 and the second schedule of CLPA are not set in mandatory terms, but provide a guide as to what is required to constitute a valid mortgage. The indenture in this case satisfies the requirements of section 45 of the CLPA and constitutes a valid mortgage. The appellants contend that the judge was wrong to say that this case was brought under Order 77, Rule 1, Paragraph A, and Paragraph D of the Rule of the Supreme Court, RSC, as on its face, An originating summons was brought under Order 73, Rule 2 and 4 of the RSC. The particulars required to be, give me a minute, to be set out in Order 73 of the RSC are not essential in the originating summons commencing in a mortgagee action under Order 77 of the RSC. Further, the appellants assert that the judge should have given relief under Section 3 of the Money Laundering Act, as there was
Money Lending Act.
Money Lending Act, as there are unaccounted sums in relation to appraisals, unlawful and excessive principal and interest assessments, and an indebtedness to the appellant in the sum of $800,000. However, it was incumbent on the appellants to show that the interest charge was excessive, or the amount charged for expenses, etc., was excessive, or that the transaction was harsh and unconscionable, such that equitable relief would be given. Instead, this claim by the appellants was unsupported by any such evidence before the learned judge in the court below, and the appellants failed to establish a case for the application of Section 3 of the MLA.
All right, any comments?
Part of the issue is that the appellants tried to bring the claim as a money lending issue, as you indicated
Yes.
earlier. So mortgage is it's really like a mortgage loan. However, the court instead saw it as a mortgage issue. So Section 77 deals with mortgages under the rules of the Supreme Court, and the money lending section is 73. And so that's what they tried to do. And so they essentially said that, well, they tried to apply a different country's law. That's the first issue.
Yes.
And then they
yes.
said that, you know what, now that we have this property, I'm not going to pay because it's not valid under this other country's law. And it should be treated as though it's a money lending issue.
But what about their comment that the mortgage itself was invalid?
It would have been invalid under that the Law of Property Act. I didn't get to the point where it said which country, but as indicated, it's not that particular legislation doesn't apply here. That mortgage that they have would be governed by the Haman law, so they have to specify or raise an issue of our law.
And I want you to look at paragraph 19, 21, 26, and 28. So let me read this. This is when they argued about the delivery of the document itself. So in validity of the mortgage, paragraph 19, the appellants say that they were asked to sign pages presented to them without any terms being attached. Later, a paper was presented to them containing mortgage terms, which were not available at the time of signing the other pages. They argue that the terms of the mortgage cannot bind them, as what they signed was not a mortgage deed. Second, the appellants argue that there was no intention to be bound by the terms of the document, as the terms were not available at the signing. Third, they argue that the mortgage is invalid as a fraud, with the result that the respondent is unable to claim for indebtedness on any of the three loans. In support of these arguments, the appellants referred us to the following passage in support of these arguments. The appellants referred us to the following passage in the judgment of Blackburn J. in Zenos versus Wickham, which they say support their proposition that the mortgage is void as a mortgage deed because it is a fraud. And then they gave this little excerpt. So the judge goes, say, I entirely agree with Evans J. in the court below that, quote, it is not sufficient for a party to simply deny the validity of the mortgages and thus create a bar to the grant of the order sought. The court must be satisfied that there is some evidence which give rise to a serious issue and that the evidence is sufficiently cogent to warrant trial. Then he went on further. He says, In relation to the signing of the mortgage documents, the appellants say that Evans J. made an error in upholding the appellant's claim in circumstances where the document had not been signed by or on behalf of the respondent. However, this proposition cannot withstand serious scrutiny. In Vincent versus Primo Enterprises, Voucher Sales Limited, Lord Denning dealt with the question of delivery of deeds in the following passage at page 619. The law as to delivery of a deed is of ancient date, but it is reasonably clear. A deed is very different from a contract. On a contract for the sale of land, the contract is not binding on the parties until they have exchanged their parts. But with a deed, it is different. A deed is binding on the maker of it, even though the parts have not been exchanged. As long as it has been signed, sealed, and delivered, delivery in this connection does not mean handed over to the other side. It means delivered in the old legal sense, namely an act done so as to evince an intention to be bound. Even though the deed remains in the possession of the maker or of his solicitor, he is bound by it if he has done some act evincing an intention to be bound, as by saying, I delivered this, my act and deed. He may, however, make the delivery conditional, in which case the deed is called an escrow, which becomes binding when the condition is fulfilled. Accordingly, I fully accept the respondent's argument before us that all that is required for deeds to be binding is that they are signed, sealed, and delivered by the party to be bound thereby. Because remember, that was one of their arguments, that this whole mortgage itself was a fraud. I don't know how they came up with that logic, but that was their argument. Because you see, they had almost what? How many? Almost 30. How many? 30? Yes, 39. Different claims saying that the judge was biased, the interest rate was too high, the mortgage document was never delivered to them. And in the end, the bank won. Any comments? No comments?
I think it's really difficult to like invalidate mortgages and these loans because I mean it is a like commitment and responsibility you was grown enough to like sign and commit yourself to. So, and I think that's why they brought the fraud ground, because mortgages are so difficult to invalidate, and fraud is one of the grounds that you are afforded to invalidate your mortgage. But I mean, these banks have everything in place, and these things are so typical that it's almost impossible that you will get something like this, win a case like this.
Yeah, but I mean, the grounds upon which they sought to have this claim to be invalid really didn't make any sense.
No,
not at all.
Reaching.
I don't even call that reaching. That was not reaching. That was not stretching. Go ahead.
I wanted to Miss Archer whether or not it was something where, because if I'm not mistaken, Twinem does in-house. I wonder if it's something where that initial sales agreement between the parties and Twinem would have been bought or taken over by the bank, and that's how the bank was able to get them to just sign the documents and then present the terms of their mortgage later. I don't know. Because I know having dealt with that company, but I know that there's an initial, and only when we're ready to go to the bank, we'll present or we'll have them buy us out from the company. But I wonder if that's what happened.
Well, that part was never brought up, so not in any of this. I'm looking now at all of these claims that they made. Let me see from the very first one. Let me see what they said.
Because the initial agreement is only like maybe 2 pages long. And so I could see how they would have said there were no specific terms like the ones they're complaining of in that initial agreement.
Okay, I see it at paragraph 5. Looking at all these different grounds, it had 39 grounds. Ground number 4, say the learned judge erred in fact in that he failed to observe undisputed prima facie evidence of real property and insurance fraud, forgery, fraudulent misrepresentation, false attestations, breaches of contracts, breaches of statutory duties, economic duress, undue influence, coercion, negligence, inter alia, perpetrated against appellants by the respondent pursuant to the subject matter before the court, and should have granted the appellants the strikeout relief they sought, pursuant to the clean hands doctrine.
I have a question.
Go ahead.
Don't institutions, lending institutions have like facility agreements or commitment letters that you sign before signing these mortgage documents that don't entail or detail all of the terms of the mortgage? And are you locked in once you sign these commitment letters or facility agreements, or can you turn away and be like, no, because the mortgage has like terms I'm not in agreement with, I'm going to like back away from this agreement?
I would say as long as you have not spent the money, then why not? But if you have taken the money, if you've already started to disburse the money, then how are you going to unravel it? Only
But
way
the
you could unravel
commitment,
it is to pay it off.
right? But the commitment letters and facility agreements are prior to the mortgage sums being released to the borrower, right?
Yeah, but you've already started the chain of events.
Right. So you can get out of an agreement once you sign those facility agreements.
Yes. If the funds have already been disbursed, then no. If the funds haven't been disbursed, you're just gonna have to pay for the expenses.
Okay.
But that's why obtaining a mortgage is a very serious commitment. And a lot of people, I guess they were under the misguided direction that they could miss payments, they could stop making payments, and their house will always be there. But that's not the truth. And that's why a lot of them have lost their homes, and at the age that they're at now, it's not possible for them to obtain another home unless they get a windfall. And even with a windfall, the prices of property now is increasing. So it's going to be very hard. Okay, let me get some volunteers for our remedies of legal mortgage for next week. Give you all the time to read along with the cases I'm going to send to you tonight. I'm actually going to send the actual documents. And some of these you may only have the summary, and that'll be fine. Who wants to do Cornell versus Maltby? Volunteer, or should I volunteer you? No volunteers?
Ready to go sleep.
All right, let's go. Kwame, which one you want to do? Cornell, Albany, Sadiq? Sylvan Properties versus Royal Bank of Scotland?
When I got kicked out, though, that what was in the chat disappeared. Can someone put that in there again for me, please?
No, these are in your book.
Oh, in the book this time.
Yes, these are the book under the remedies. I wanted everyone to present one of them. Who wants to take Cornell versus Maltby? Just a summary will do.
And this is for next class, you said?
Yes, next class.
Okay, so I'll take that one.
Okay, all right. Okay, Lisa. Who will do Albany?
I can do that.
Okay. Sadiq? Gabrielle?
Yeah, I'll do it.
Okay. Sylvan Properties? Ashley?
Okay.
Okay. Downside nominees? Kwame? He didn't say, he just looking to see where that is quick.
You really want me to do that?
Yeah.
What's the name? What's
Downside.
that again?
Downside.
Okay.
Downside nominees versus First City.
Okay.
Okay. Who'll do the next one? Saquon versus Wongshi. Trying to find it, right? TSE.
I'll do that one.
Okay, Kenneth. All right, and then I have the Standard Chartered Bank is already in here. Someone could do Baxter versus Gap. LaShawn.
Okay.
Okay, and then we have Swing Castle. Who's left? Camille? And other than that, what else we have?
Okay, Swing Castle.
Yeah, Swing Castle. We have Parker. We are not gonna do all. Parker versus Dunbar.
Okay, I'll take that.
Oh, I hear that. I hear that one quick. Okay, that should be it. So in addition to these, soon as we hang up tonight, I'm going to now send you the cases for us to read next week, so we don't have no delay next class. Everybody will be on the same page, and everybody will be able to participate when we discuss the cases. So next class is module 4, and we're gonna talk about the mortgagor's duties and liabilities. And we'll also talk about the Homeowners Protection Act, which I know you're very familiar with now. And I do have a case on that too. So I'll also send that so you can read that case also. Okay? So we're good?
Yes, ma'am.
Yes, okay. So let me put these cases together to send to you all for next class. Okay? Let me see if I can. And anybody who doesn't receive it by in the morning, let me know. Send me an email.
Will do.
Okay, because I'll try to send it to everybody tonight. All right, so happy reading, and hope we'll have some at least more provocative discussions next class, because you'd have had time to read it. Okay.
Yes, ma'am.
Okay, all right. So good night to all.
Good night.
Good night.
Good night.
Good night.
Good night.
It's 8:30. Why are you out here? Pardon me?
So you done paid your scam. I'm tired, but I'm fine. When you need to put your foot, something on your foot. While you out here, you might as well get your medicine. Come get your medicine.